Now coming to the purely legal concept of discharge by way of frustration. This is a purely legal issue. It's not a contractual term or a contractual clause. So, and they say that there is no better way to exercise your imagination than the study of law. No artist can interpret nature as freely as a lawyer would interpret a contract. So here, again, while talking about discharge by way of frustration, you have cases which have evolved before the Supreme Court from 1954 to 2017, giving us a robust 70-year jurisprudence of how courts will look at the doctrine of frustration, the doctrine of impossibility, and what kind of reliefs may be granted by the courts. Now, again, talking of frustration, frustration is something so significant which happens independent of a contract that it becomes virtually impracticable or impossible to continue performing the agreement, and the agreement has to be put to an end and the parties to be discharged. Here, looking at 70 years of case history, if I were to cull out 4 or 5 principles, they would be as follows. The remedy of frustration is an exception and it is not the norm. As a general principle, courts are highly reluctant to give you a remedy of discharge by way of frustration, and it is only in exceptional cases will they grant such a relief. So that is something to be kept in mind at the threshold. Number 2, simply because a contract becomes onerous or difficult to perform or expensive to perform, if there is a commercial risk or an increase in price of raw materials, it does not amount to frustration. For it to be amounting to frustration, there has to be something which is far more grave, far more significant, far more permanent in nature, which requires to take place. For example, if there is a material natural calamity which renders the performance of the contract completely impossible, if there is an earthquake or a flood or a storm which completely destroys a property, for example, in a leave and license agreement. All these examples where there is something grave which completely changes the balance of a contract would be situations under which a remedy of frustration would be granted. So that is again something to be kept in mind. Number 3, as opposed to force majeure, there is no concept of suspension of obligations while talking about frustration of contracts. So the only remedy here, if you successfully establish frustration, is discharge of parties, and the contract will be put to an end, it will be terminated, and the parties will be freed and discharged of their obligations. And lastly, for you to get the remedy of frustration, there has to be something which is far more permanent in nature. There has to be some semblance of permanence in the happening of an event. So therefore, the question keeps coming up is whether the COVID-19 pandemic or the lockdown would amount to a frustration event. And many a times we will see that both lockdown and the pandemic in that sense could be temporary in nature. So they may lack the element of frustration. Of course, it has to be seen on a case-by-case basis, but that has to be evaluated to see if there is a semblance of permanence in the issue complained of. And to give you an example, recently to deal with COVID-19, Bombay High Court had the occasion to deal with a case in the matter of standard retail, where there was a contract for shipment of steel products between a party in Korea and an importer in Mumbai. So the shipment was dispatched, and after the dispatch, the COVID-19 pandemic broke out, the lockdown happened. So the Indian importer approached the Bombay High Court and said that he could no longer take possession of these products because of the lockdown and the pandemic. He was unable to perform and the contract was frustrated, and therefore consequent interim relief should be given for the purpose of encashment of letter of credit in that case. So the Bombay High Court looked at the situation and said, no, there is no frustration. COVID-19 and lockdown is a temporary event. For it to amount to an event of frustration, you need something far more permanent. And in this case, the goods have already been shipped. Further, steel at that time was notified as an essential commodity, and therefore there was no excuse in that sense to get rid of contractual obligations, taking recourse to the doctrine of frustration. So here, the remedy was refused, and the argument that the contract was frustrated because of the lockdown and the pandemic was, in that sense, refused. Now, to give you examples and cases, I will give you two cases, one of the exception and one signifying the judicial norm while you deal with cases of frustration of contract. So first, let us talk about an exceptional case where the remedy of frustration was granted. This was a case which I had handled for one of my clients in Madras, Chennai. And the case pertained to the Chennai port. Now, the Chennai port, like any other port, had around 10 to 15 berths. Now, berths are places where ships come in and berth for the purpose of loading and unloading of cargo. So there were around 10 to 15 berths. Now, in 2004 and 5, the situation was such that there was a large volume of traffic of vessels which was coming or calling upon the Chennai port. And as a result of which, there was complete congestion and the vessels had to wait in queues for their berthing turn to come. So they had to wait for the prior vessels to load, unload, and move forward for their berthing turn to come. And many a times, it would take days and sometimes even weeks for their turn to come for berthing. As a result of which, obviously, there was a lot of damage in terms of time as also finances. So the government, they came out with a scheme which is called a berth reservation scheme, where one of these 15 berths would be given on an exclusive license for a period of 20 years to a licensee who would pay in advance the entire berth hire charge to the port in the beginning of the year, and he would have exclusive license over this berth, which he could in turn give out to ships and shipping lines, where ships could be given the facility of priority berthing for payment of a premium. So there was a bidding process, and my clients won the tender, and they got the exclusive license for one berth at the Chennai port, and consequently, they entered into a number of agreements with various ships and shipping lines, giving them the benefit of priority berthing. So the shipping lines would pay an extra premium to our client, and they would get the benefit of priority berthing. They would jump the queue, go ahead of other vessels, and get priority berthing space for this extra premium. In 2014, the contract was running very well from 2004 to 14. But in 2014, something unique happened. Madras High Court, in a PIL, passed an order saying that there will be a complete and total ban on handling of any dusty cargo in the Madras port. So any ship or a vessel carrying dusty cargo like coal and iron ore was completely banned from accessing the Chennai port. And a new port called the Ennore port was constituted around 80 kilometers from Chennai, where there was all the dusty cargo vessels carrying coal and iron ore were diverted to Ennore port. This situation of ban of handling dusty cargo and access to vessels carrying dusty cargo in Madras port resulted in a situation that there was a drastic drop in the volume of traffic calling on the Chennai port. So this was a drop to the extent of almost like 50 to 60% of the vessels which no longer were able to access the Chennai port. Now the situation completely changed. There was no traffic congestion. There were no queues. The berths were easily accessible and available. So any shipping line who wanted to berth, they would easily get any berthing space amongst the 15 berths. And there was no reason for them to continue the contracts with our clients and pay our clients an extra premium to get priority berthing, because there was no need. There was no traffic, there was no congestion, there were no queues. So there was no need to avail the facility of priority berthing by paying an extra premium. So in that sense, the contract had really lost its significance. However, the port authorities insisted that my clients should comply and continue to perform and continue to pay them the advance license fee every year. So my clients approached the port. They told them the contract is frustrated. There is no point of continuing this contract. None of the shipping lines want priority berthing anymore. But the ports refused. Once the government authority, that is a port which refused, we were constrained to approach the courts. And the courts, looking at the situation, looking at the contract, held that yes, the contract was frustrated. Then the reason being that traffic congestion and volume of traffic was the essence of the priority berth reservation contract. Once there was no traffic, once there was no congestion, there was no need for anyone to avail priority berthing. And therefore, the berth reservation scheme and the contract had completely lost its significance, had completely eroded, and there was no point of continuing with this contract. The contract was completely frustrated and the parties were discharged. So my client was discharged from performing any further obligation under the contract as a result of frustration. So this is a unique situation where you see that the contract was held to be completely frustrated as a result of a subsequent event which happened, which was unforeseeable. Now looking at the norm the other way around, I can sum up the entire jurisprudential history by one landmark judgment passed by the Honorable Supreme Court by one of the most brilliant judges, Justice Rohinton Nariman, in 2017 in the matter of Energy Watchdog. So here the situation was that there was a bid for power producing and power supply, where various power supplying companies participated. One of them won the bid at a particular price. Now his pricing, what he bid for, was based on the fact that he had back-to-back arrangements with certain companies in Indonesia for supply of coal, which is a raw material you need for the purpose of manufacturing power, at a particular subsidized price. So on the basis of this back-to-back arrangement, he put his bid, won the contract was signed. After entering into the contract, there was something significant which happened. The government of Indonesia brought in a change in law. As a result of this change in law, the price of coal, which was the raw material, skyrocketed and it shot up. And it was no longer feasible commercially for these power supply companies to continue their contract in India at the same price, because the price of raw material, what they expected, was very different. Now it was very significantly enhanced, and they did not want to continue at the same price and the same cost because it was very, very difficult and financially onerous. So they approached the government and said that the contract was frustrated. There was a change in law which happened subsequently, and that they should be discharged for frustration. The government refused. The matter was litigated and it went to Supreme Court, where the Supreme Court in this situation held that no, there is no frustration in this case because the contract is for supply of power, and nowhere does it state that only Indonesian coal should be the raw material. You can always go ahead and source the raw material or coal from an alternate source, even though it is twice as expensive and even though it is logistically difficult. You still have to perform, and you cannot excuse yourself from your obligations just because of a change in the price of a raw material. As long as there is an alternate source available, there will be no remedy of frustration which will be given. So this essentially summarizes that business risk, commercial risk, change in prices, fluctuation in prices will not enable you to discharge yourself from a contract on the basis of frustration. And even while deciding this case, Supreme Court laid emphasis on an English judgment where it was a contract for shipment of certain goods from one country to another. And in those days, they used to use the Suez Canal for transit, which was the shortest route. Now, what happened in 1954? There was a warlike situation and Suez Canal was closed. So the shipper wrote a letter to the other side, the purchaser, saying that the contract was frustrated because he could no longer access the Suez Canal, and this was because of war, which was beyond his control. When the matter went to court, the court said, no, there is no frustration, because even in this case, though Suez Canal is blocked, there is an alternate route available, and that route is via the Cape of Good Hope under South Africa. And even though this route is twice as long, and even though this route is twice as expensive, you still have to perform your contract. Just because a contract has become expensive and onerous to perform it does not mean that you will be discharged on the basis of frustration. So this essentially summarizes our position on contracts and frustration of contracts. And we deal and grapple with a number of issues which will crop up in the days to come as a result of the lockdown and its impact on various contracts, where parties will have to evolve. They'll have to evaluate their contracts and see what are the rights and remedies which are available to these parties, which can be taken recourse to as a result of this very, very unusual situation that we are facing today.